In 1971, this man argued and won a case before the Supreme Court. You were only 27?
Yeah. I had just graduated law school a couple of years earlier and had never really practiced law. I and my colleagues had virtually no litigation experience, no appellate court experience, almost no court experience. There was no one in our office. This was the birth of a new legal aid system, community legal services and others around the country, and there were no elders or partners or experienced people who did this work. So we were doing it for the first time, and we were learning as we were going along.
So what was that emotionally like, getting up in front of these august figures?
I'm sure it was a little unsettling. On the other hand, I was sort of confident of what I was doing, and you're pretty prepared.
This past January, I uploaded a movie about the Leah Stein Dance Company. On the title screen was a black and white photo from some decades ago, and on the far left was a thin dancer with graying hair. Leah told me his name is Jonathan Stein, no relation to her, and that he was a celebrated progressive lawyer and great supporter of dance. A few weeks ago, Stephen Salisbury published a story about Jonathan, and after reading it, I knew I had to make a movie about him. You will see Jonathan's performance in a minute, but as we watch him get ready, let's hear him answer some of my questions. How did you become a dancer?
I began taking modern and postmodern dance classes in the 1970s and contact improvisation in the 1980s, mainly to address my curiosities about dance and to pursue creative efforts that joined body and mind. I began performing at age 45 in 1989 when dancers and choreographers asked me to join their work, and now have performed in over 24 dance works, including in live arts fringe festivals and at the Kimmel Center.
Do you have any friends in the legal world who also express themselves in some kind of artistic manner?
I have one friend, Jermaine Ingram, who has been both a lawyer and is a consummate artist in a host of media, including dance.
Have you managed to bring your colleagues from the legal and dance worlds together?
Bringing colleagues from the legal and dance worlds together may be too formidable a task. I do encourage lawyer friends to discover the creative energies of dancers performing, and on occasion, try to direct legal assistance to struggling dancers.
Any advice for fellow lawyers and doctors and those in the straight-laced professions about how to find a creative outlet?
My advice is just to dive in as I did 50 years ago. At whatever age you are, take classes, take workshops, immerse yourself in performances as active listening audience. Read broadly about the arts, including the online dance journal that I have been writing and editing this past decade. Its name is thinkingdance.net. It's free and a great pathway into dance.
We are beginning in 9, 8, 7, 6, 5, 4, 3, 2, 1. Hello. My name is Jonathan Stein. Forward means to move in the direction you are facing. But onward means moving forward in a continuous motion, never stopping, always keeping in mind who we are serving and who needs help navigating the labyrinths of power. Here at Community Legal Services, we have been representing low-income people for over half a century in our mission to fight the violence of racism and poverty and change the systems that maintain these structures of injustice. The focus of this citywide symphony, Rehearsing Philadelphia, is on locations of power. You have all arrived at Community Legal Services, the power that fights City Hall, fights the United States government, onward, moving onward together beside those we serve. We are the power standing with immigrants, the poor, children, and those with disabilities. Today, we will focus on 3 cases from our archives of justice. Case 1, Graham versus Richardson, 1971. Please hold your left elbow.
Feel the law in your body.
Cradle your elbow.
Hold it.
In 1968, I joined Community Legal Services after graduating from the University of Pennsylvania Law School. In 1971, when I argued the Graham versus Richardson case before the United States Supreme Court, I was 27 years old. The 9 justices of the 1971 court included Chief Justice Warren E. Burger, Thurgood Marshall, William O. Douglas, Harry A. Blackman, Hugo Black, Byron White, William J. Brennan Jr., Potter Stewart, and John Marshall Harlan II.
My argument before the Supreme Court.
My oral argument before the court was that restrictions on welfare benefits for legal resident non-citizens violated the 14th Amendment of the United States Constitution under the Equal Protection Clause and also under the Supremacy Clause.
And I told the court,
Mr. Chief Justice, may it please the court, we have before us today a case of alien discrimination, which is rooted in the prejudice and ill will of an early year in Pennsylvania. The fact this was passed at a time of war hysteria and anti-alien feelings in Pennsylvania was made clear in a memorandum commission, a study commissioned by the state, by the Welfare Department, which is part of the record. In addition, this law, which was passed in 1939, was passed within 5 days of the state's Alien Registration Act, which this court struck down in Hines versus Davidowitz. And in a sense, the motivations behind a citizen requirement are not unlike the motivations behind the residency requirement, as in Shapiro v. Thompson. Both rest in a basic distrust or dislike, perhaps a fear of the foreigner, of the out-of-state person. What is really, I think, at issue here, in terms of what is the basis of the Pennsylvania statute, is really an assumption that aliens are less deserving than citizens. But it has been judicially recognized that aliens have contributed their energies and their tax dollars to this country. They have often been long domiciled in this country with a history, a work history, a productive history of contributing to the state of the nation. They have established families and reared children. They have entered into the social and religious fabric of this nation. And of course, they have obligations to serve in the armed forces.
And I told the court later,
I'd like to say in conclusion that we are really, as President Kennedy's book set forth, a nation of immigrants with a proud tradition. And the strengths of our history reside in the fact that when immigrants have come to our shores and to live among us, they have been afforded equal treatment. This tradition has often required the protection and vigilance of this court when such immigrants have been met with ill will and prejudice when they have come to this shore. And appellees stand before this court today seeking this protection. And I respectfully request that this court affirm the decision below.
and we won a unanimous decision, a 9-0 decision of Justice Blackmun. We won the case.
We are moving onward, which is forward in a continuous motion. Case 2, Resident Advisory Board versus Rizzo. Please squeeze your left shoulder.
Feel the law in your
Hold your shoulder.
Hold it.
In the early 1970s, angry white residents of South Philadelphia protested the development of Whitman Park, a housing development of 120 single-family subsidized row homes. Our clients in this case were African-American families who dreamed of finding a safe, stable place to live. At Community Legal Services, we believe they deserve to be part of the city, just like everyone else.
They came to us for representation when then Mayor Frank Rizzo, and some of you do remember Frank, blocked the construction by supporting
President Richard Nixon was in the White House at this time, and he was supporting northern white opposition to civil rights. Nixon's staff told the Federal Housing Agency, HUD, to stay out of the Whitman Project case in Philadelphia to support Rizzo's discriminatory policies, essentially killing the construction project.
But this violated the federal 1968 Housing Civil Rights Act.
Also known as Title VIII, the Fair Housing Act was a major accomplishment of the 1960s civil rights era. It prohibited discrimination in the rental, sale, or financing of housing based on race, religion, national origin, or sex.
Fighting for housing was Nellie Reynolds and her Resident Advisory Board.
Resident Advisory Board was one of the nation's first tenant councils. Nellie recently told a reporter for the news source Shelter Force how the white protesters treated her during the federal court trial. Quote, "I was there every day," she said. Quote, "and they were terrible acting in court. There was a mob of them waiting out there for me. They would stand by the elevator waiting for me to get off, and they would call me all kinds of names. I would act like I didn't hear it. The reporters were always asking me why I didn't cuss them back. And I would say, because I'm going to be their next door neighbor. You think I'm going to fight with my neighbors?"
Nellie Reynolds and the RIB and their courage was soon to make history.
It was my job as lead counsel to take Mayor Rizzo's sworn deposition, which would be critical evidence in court to prove the mayor's motivation against integrated housing. Under oath, the mayor admitted that he sided with the white protesters against a racially diverse neighborhood. Rizzo's own words established the finding of intentional race discrimination by U.S. District Court Judge Raymond Broderick.
We proved intentional housing discrimination for the first time against the city of Philadelphia and its mayor.
And proved that the impact of stopping the construction of the 120 homes meant that African Americans were denied equal housing rights. As the court stated, quote, "Here, the discriminatory impact of the city's obstruction of the project could hardly be clearer." Mayor Rizzo stated that he considered public housing to be the same as black housing and felt that there should not be any public housing placed in white neighborhoods because people in white neighborhoods did not want black people moving in with them. Furthermore, Mayor Rizzo stated that he did not intend to allow the Philadelphia Housing Authority to ruin nice neighborhoods, end quote.
And the court continued,
quote, "The city must be charged with knowledge of the fact that the cancellation of the Whitman Park Townhouse project had an obvious disparate effect on the black community. We also find that the evidence in this record establishes that the city of Philadelphia acted with racially discriminatory purpose in halting the Whitman Park Townhouse project and in canceling the contracts with Multicon, the developer," end quote.
We won the case.
We won the case.
And thanks to this lawsuit and a vigilant judiciary, 120 homes got built at Whitman Park in South Philly, a beacon to subsidized and integrated housing.
We are moving onward, which is forward in a continuous motion. Case 3, Sullivan v. Zebley, 1991. Please place your hand over your heart.
Feel the law in your body.
Your heartbeat. Feel your heartbeat.
Do you feel your heart working in there?
In 1991, Sullivan v. Zebley was the largest case any legal aid program in the country had ever taken on. At this time, the U.S. Supreme Court Chief Justice was William Rehnquist. We wanted the Zebley case to expand eligibility for low-income children with disabilities to receive SSI, also known as Supplementary Security Income.
But we knew the odds were stacked against us. This was a very conservative court, so we knew we had to mobilize an army of support.
I spent a lot of time marshaling every major child disability and medical organization to be friends of the court to support our position. The American Medical Association, the Easter Seal Society, Children's Defense Fund, the American Psychological Association, the American Psychiatric Association, the American Academy of Pediatrics, and many, many others, including 29 state attorneys general. And in working together, we won the case.
Our CLS team was very proud of winning this case.
This meant that the program went from helping 200,000 disabled children nationally to 1.3 million. Too successful, because the Zebley case angered many Republicans in Congress, especially around mental disabilities, claiming that it was a sham and that these children just needed services and not added income. Fueling the backlash fire were irresponsible media reports saying that parents were getting, quote, crazy checks, end quote, and that they were manipulating IQ tests by, quote, coaching, end quote, their children on how to fail the test on purpose. A mythology was building around abuse of the program, and the pushback was very real as it went up the media food chain to more prominent newspapers until it was on ABC primetime television. We then worked successfully in Congress to save Zebley and the expanded SSI program from being totally dismantled.
Zebley also meant more than added income to low-income families with disabled children.
Something essential to note is that when children with disabilities qualify for SSI, this makes them eligible for Medicaid or medical assistance. Many of these 1 million new children had never had proper medical care until we won Zebley. For some families, Medicaid assistance was more important than the income benefit. As we know, especially before Obamacare, access to health care for poor and working families was a significant challenge.
Edward Berkowitz, professor of history and public policy at George Washington University, had this to say.
It was lawyers, rather than congressmen and other politicians, who brought the problems of the nation's disability system to public attention. They dealt with people who were denied benefits or who had their benefits cut because authorities deemed them to be no longer disabled. This experience also brought the dilemmas of children to the attention of lawyers and other advocates, end quote.
David Super, law professor at Georgetown and also a lawyer here earlier, had this to say 25 years after Zebley.
Quote, all too often, public policies treat individuals like objects, uniform and devoid of humanity and distinctive experiences. Programs serving low-income people in particular fall into that pattern. But what a grim irony it was that for so many years we afforded the most inflexible, dehumanizing treatment of all to evaluating the needs of our children with disabilities. Had it not been for Zebley, that approach would clearly still be in place today. Zebley was a victory for due process, for professionalism, and for millions of low-income families. Perhaps most important of all, however, it was a redemption of our fundamental humanity, end quote.
Peter Edelman, law professor at Georgetown, had this to say also.
We know what Zebley has meant for millions of children and the powerful difference it has made for so many. My personal note is this. Every year, I tell my poverty law students that Zebley is Exhibit A for the proposition that impact litigation can still be the agent of change of historic dimension, end quote.
In 1991, the Social Security Commissioner was Gwen King, and 25 years after she was in the courtroom at the Supreme Court, she had this remembrance.
That day was also my introduction to Jonathan Stein and Richard Weishaupt, two lawyers relentlessly pursuing justice for the most vulnerable among us. The admiration and appreciation I have for them and community legal services is enormous. I had them both on my list of people to call whenever I needed a sounding board, a fact checked, a course plotted on the path to justice for kids. When I was told something could not be done, my CLS, quote, adversaries, end quote, found a way to do it. Together we argued, agreed, disagreed, revised, and came up with workable, not perfect, but considerably improved government rules, end quote.
So here I am. I'm 78 years old, but who's counting? And I'm supposedly officially retired from the law, but unofficially.
We hope you enjoyed this solo performance at Community Legal Services. In 1968, I graduated from the University of Pennsylvania Law School. Almost a century earlier, Henry Mercer also graduated from the same school with a law degree. He became an artist, most famous for his Mercer tiles.
Outside these windows are original Mercer tiles celebrating the lives of working people.
We cannot stress enough the importance of creativity. The more creative we are, the more we nurture our imaginations and expand our awareness of the world around us. In effect, improving every aspect of our lives.
So the law remains in my heart and my head. The dance moves
We
in
are
my body.
moving onward, which is forward, in a continuous motion.
I'm a dancer moving onward, which is forward in continuous motion.
Thank you for joining us today at Community Legal Services.
I have to thank C.A. Conrad, the collaborator with me in this work. After interviewing me and tape recording and doing his own research, he created this work, the script of 25 minutes of both my recorded voice, and spoken live voice, and then set some movement to the rest. So he is an extraordinary fellow, not here. He's in London, he's in Spain, he's around the world. I also want to thank Andolyn Young, who's over here, who's making all this happen. Thank you, Andolyn. She's been here at every performance, making sure everything works. So that's a really important support. And I would like to thank Community Legal Services, who's given me this gift. So thank you so much.
If your tombstone sadly is small and you only can fit one of those three cases on it, which one would it be?
It would probably be the Zebley case, because there's about 1 million children who benefited. It's actually many millions, because the case is 30 years old. So there were many millions of children who've gotten SSI children's disability benefits from 91 on. The families have gotten a cash benefit and a health benefit, which is medical assistance.
Do you see a relationship between your dancing and your lawyering?
I once thought that lawyering and dancing were two separate spheres of my life, but now see that improvisation is a vital source of energy and innovation in both. And that indefinable quality of creativity also nurtures both a professional work life and a dancing life.
John, the appearances before the Supreme Court, you're not just reading from a script. You have to answer their questions. Yep. Is that an improvisational thing?
Yeah. Thinking on your feet, you do have to be in the moment and be responsive to questions of justices. Some justices are asking questions that really show their antipathy to your position, some don't. I remember in 1971, Justice Blackmun, he asked me sarcastically, "Are you going to come back next year, Mr. Stein, and argue that aliens who are not citizens have a right to vote?" I, of course, had to dance around the question in an improvisatory way and deflect it. That's not the issue today. There are differences between a right to vote and a right to welfare here.
What's it like to dance to spoken text as opposed to music?
Text hits your brain in a different way, I guess, than music, but it's almost the same kind of listening that you do as a dancer. If you're present, if you are in the moment, which is an ideal that I can't create every moment of 25 minutes, you're listening, and it's an active listening. It's an active both oral listening with the ears, visual listening with the eyes, and bringing that into what movement you're creating on the spot.
This is the first major work that I have created and been the choreographer and dancer in. My other 24 performances going back to 1989, I was a performer-dancer in other people's creations. So this was a big challenge for me, a wonderful challenge. Felt very fulfilled by it and felt I had the tools and the abilities after dancing in workshops and classes and other performances to improvise and provide a little bit of set phrases that one could call choreography, things you come back to, but mix that with improvised movement. And that's what I did here.
Well, it was totally enjoyable, and thank you for letting me witness it.
Okay, thank you too.